Before we go to questions from staff, do we have any ex parte communications on this item?
Yes, I do. I was contacted by Kim Pascuto with the Ag Tourism Coalition, and I met with her, and she wanted to express her concerns of weddings and events on ag lands, specifically the impacts to the rural area, the roads, the noise, the traffic, and her belief that it could be overwhelming to the ag lands. I also attended the Paso Chamber sponsored, along with Supervisor Meacham, town hall panel discussion at the Hampton Inn in Paso Robles, and afterwards I met with Chair Christie and Dorothy Jennings and Susan Harvey from North County Watch and Kim Pascuto again from the Ag Tourism Coalition. There was very little discussion on this item, but I felt I should disclose that since it was concurrent right after the town hall meeting. So that's the extent of my contact.
Yes, I received about 12 to 15 phone calls. I didn't keep a record of it because I didn't know there's going to be this many. All of them in opposition to either eliminating the ag portion of this, or all of them that, or against the event ordinance itself, and some were against both of them.
I also have some contacts. I did speak about events with B.K. Richard and Bob Vesely at a meeting 2 days ago, and specifically we talked about issues regarding historically designated structures, more specifically the Octagon Barn, and the impacts of the ordinance there. I've also communicated by email with Kim Pascuto and Elizabeth Rolfe, and specifically we've discussed there the conflict of interest charge lodged against me, and the response from the FPPC, who I have contacted. And for reference for anyone out there, then the FPPC has assured me that my small youth hostel is not operating in conflict to this ordinance. And because the zone of real estate that I hold, commercial retail, and is amongst the many zones affected by this countywide, I have had adequate reassurance that I don't have a conflict.
Yeah, as a legislative decision, I'm not really sure how much ex parte we really actually have to disclose since there's no actual particular applicant, but I have talked to the Ag Tourism Coalition, and Richard Enfield from the 4-H Youth Development and the advisor to the UC Cooperative Extension talked to me yesterday about this item.
I too attended the Paso Robles Chamber Forum with that Supervisor Frank Meacham hosted, and obviously was attendant in the meeting afterwards with Kim Pascuto, Elizabeth Rolfe, and Sue Harvey and Dorothy Jennings. But as Commissioner White stated, we really didn't talk about the ordinance per se. We talked about more sort of wide-ranging issues. I also attended the San Luis Obispo Chamber Forum here in this room on Monday, and I spoke with Danielle Sapriella of CABO, Kim Pascuto from Ag Tourism Coalition, each of whom had requested 10 minutes to make a organized presentation for this hearing. I said yes to both of them in consultation with Commissioner Wyatt, who served on the subcommittee. And I also invited, through Ms. Pascuto, Jerusha Greenwood, from a professor from Cal Poly who has expertise in tourism and recreation, to make a presentation as well. And those are some of my ex parte communications. And I did want to acknowledge Commissioner Christensen's question about ex parte communications for legislative matters. My understanding is you are correct. They are not required, but we've sort of always lumped them together for obvious reasons. So thank you for that. Questions of staff before we go to public comment?
Yes, just a couple. Ms. Null, I think it may be helpful to start with an explanation of what the baseline requirement is right now, as we're looking at changes to an ordinance, what's required now or what events are allowed currently on parcels.
Okay, very simple ordinance that's been in place for years. Nonprofit events are exempt, and any other type of event that's not one of the exempt categories would require minor use permit approval.
Minor use permit. And what about the nonprofit, the symphony concert that keeps getting referred to? Is that not a nonprofit?
It's not subject to the temporary event ordinance because it has more than 3,000 people, so it's considered commercial outdoor, commercial outdoor entertainment, temporary commercial outdoor entertainment, which is part of Title VI.
So size kicks it up to that level.
Correct.
And so what's the threshold then for that higher level of permit? What size? Is 3,000 the threshold?
Anything over 3,000, the existing Title VI would apply, and you need to come to the Board of Supervisors for a public hearing.
Okay.
For a business license.
So right now, any event between 50 people and 3,000 requires a minor use permit?
Unless it's one of the exempt categories, correct.
Okay, so except for the exempt categories, any single event over 50 and between 3,000 requires a minor use permit?
Correct.
Okay, and what's the baseline cost for that minor use permit now?
Let's see, $3,500 to $7,500.
Tell me again?
$3,500 to $7,500.
Okay, so right now if I legally wanted to have one event, I'd have to pay at least $3,500 to go through the minor use process?
Correct.
Okay,
Am I
thank
missing
you.
something, Ms. Griffin?
I don't have the ordinance in front of me, but I believe the minor use permit is to allow for more than 4 events and 4 subsequent weekends. Let me get the ordinance and then we can actually speak
It would
about
just be handy as we go through the process of change
It is
to
in
have
your
some
staff report,
understanding.
beginning on page, I did include the existing ordinance.
Right, I read the staff report, but I have a feeling a fair number of the people in the room have not. So I thought some general understanding of that baseline would be helpful.
The current time limit is that a temporary event is allowed to be held in a single location for no longer than 12 consecutive days or 4 successive weekends, except where a different time limit is established through a minor use permit. So that's, you have the exemptions, so it's a minor use permit except for events occurring in approved theaters, events occurring on land in public ownership like parks and things like that. And then other free admission events which are 8 hours or less in duration and are operated by nonprofits. So that's what we always call the nonprofit exemption. And then the 3,000 or more are subject to that commercial outdoor entertainment Title VI requirements, which is a business license that's heard by the Board of Supervisors. No land use permit at all. And then parades and things like that are fine. There's some location requirements. The site of any event other than a parade or something in a public park has to be farther than 1,000 feet from residential single family. And then you're required 2 access points and adequate parking, fire protection, and sanitary requirements, water supply and restrooms. And then a guarantee of site restoration afterwards.
Thank you.
Any other questions of staff before we go to public comment?
I do.